Viewers, and welcome to MR Solicitors Facebook live session once again with our panel discussion here. And in my panel today again we have the same members of the panel. We have our guest Qazi Imran Iqbal, we also have Salman Nabi, we have Sonia Beg on my left, and then we have Nazir Ali Sahab. So thank you very much taking out time for this session. There are not many immigration updates in the last 1 week, but a question which has been coming up over and over again, time and time again, and that question is people are asking, okay, number one, if there is going to be any amnesty announcement from the government. And the answer time and time again is we don't know, but the second part of it is very interesting. So many people are thinking, even in legal fraternity, the lawyers are saying this, that yes, there is no announcement and there may be no announcement on amnesty, but actually Home Office somehow has started granting status to everybody or to whoever is making an application, and then there are some sites where some type of forms are even mentioned. So I'm just trying to assure you there is nothing like that. But what it is, say for an example, I give you an example. Example is that Home Office has this rule that those people who have been in the country for 20 years, and if they can prove their 20 years long residency, they can get status. There's another category which says that if you are in country but for less than 20 years, you can still make an application. But what they want to see, they want to see different factors. And the main factors they want to see is whether you have lost your social, your cultural, your economic, your family ties with your country of origin. And obviously, if you have developed those ties in UK. This is something which Home Office, and this is my personal experience as well, I'm adding in, that Home Office used to refuse these applications, that if you have been in the UK for 12 years, 15 years, not 20 years, and you are trying to argue on these grounds, Home Office very often refusing these applications. However, that has been changed, and I have so many applications where the applicants are in the UK for less than 20 years, anything from 12 to 18, 17, 18 years, 19 years, we have made applications and we have got successful decisions. However, as I said, you have to come up with very, very good application in terms of justifying your social ties with UK, your cultural ties with UK, your family ties, if possible, with UK, your economic ties with UK. And I give you a little hint, and this is little hint as this is my 21 years of experience in immigration, and this is my hint. Not necessarily every lawyer will accept this argument. That for an example, if you have a certain skill or experience in the UK and you want to do the same thing, why don't you create a very good business plan and say that, look, if I will be granted status in this country, I'm not going to go for and look for job or go for benefits. Actually, I'm going to establish my own business. I'm going to create job opportunities for UK residents. And this is just a little one hint. Then there has to be to back up the business plan, you have to have your experience or education or your skills or your financial strength, and there are practical ways how you can do that. So for that you have to have your solicitors on board, legal representatives, and you go and discuss with them, explore everything, explore your family ties here, for how long you have not been in touch with your family members or friends in your own country of origin, cultural issues. For example, on a lighter note, football is culture of UK, right? So what do you know about football? Which teams do you support? Anything to do with social activities, anything to do with UK culture, please get that in. So this is very, very important, and this is just one update I wanted to give you, because there are so many questions, again same common questions, and it may be the case that we start receiving again these questions today about amnesty. So we will continue taking questions on Facebook and some emails, inquiries we have, and we have quite a few inquiries in relation to non-immigration matters, and I would start with Salman, with you. There are a few questions I have for you because we have received emails from clients who would like to know. And I'll give you an example because I don't want to mention the name. So I give you a scenario. For example, a person who is, say, about 68 years old, and he has one wife only and 3 children, 3 sons, say, presumably. So he's worried after his death, his properties in the UK may not be distributed as per Islamic Sharia law, which he wants to do it. They may just follow the UK probate regulations, rules, UK law, and it will be done. Or probably if he has a daughter, you see, under Sharia law, it is half of the share which you give to son. But I just want to add, this is my information, that in your life there is no recommendation that you give half of the share according to your son's share to your daughter when you are alive. When you are alive, you give whatever you want to give, 50-50 or more or less, but this is only after your death. This is the Sharia law which comes into force. So this is the question for you, if you can shed some light on that.
Thank you very much. This is actually quite a common inquiry from a lot of our clients from the Muslim community, because many of you may not be aware that the succession laws of the UK, if someone dies without a will, do not necessarily follow a distribution that complies with what the Islamic Sharia law requires. And also, you have to be aware that under Islamic Sharia law, you can make a will, but your will can only regulate 1/3 of your estate, or 1/3 of the whole of your properties. So what we suggest and advise our clients to do where they wish their inheritance to be dealt with in accordance with Islamic law is to make a will. And the will ensure that the properties that a person has are distributed in accordance with the rules of Sharia, and that can regulate the whole of their property. And 1/3 of his property, obviously his UK will deal with the entirety of his wealth. But in a situation where you want your succession and inheritance to be exactly the way Sharia requires, the only solution is to make a will. And the will can be formulated in a way that reflects what Sharia requires of you. It can reflect any of your own wishes or anything else you may want to add, or to benefit anyone else that may not necessarily be covered under inheritance law or even under Sharia law. So I think the best advice that I can give you is to consult your solicitor and make a will sooner rather than later, because that will ensure your inheritance is dealt with exactly how you want it.
Yeah, thank you very much. A similar kind of question with different details. Say someone has asked that my mother is 81 years old and she has made a will when she was about 55 years old, in which she gave all her properties to him. A few years ago she married again and currently lives with her husband. I have recently heard that she wants to make another will. If she makes another will, what happens to her earlier will, and how can we prevent her from making a new will? Because probably new will, he's not the beneficiary.
Yes. In the general rule is that if you marry, if you get married, any will you made before marriage is invalid. It basically cancels your earlier will, unless the will was made in contemplation of your marriage. Now you say your mother made the will when she was 55 and she got married again a few years ago. On the assumption that her marriage was a long time after her will, it may be that her earlier will, where you were the beneficiary, is cancelled anyway. That will is not valid and enforceable. So at the moment, she is without a will. In what lawyers would say, her properties will be dealt with in accordance with the laws of intestacy. And if she dies without a will, which she is now. She doesn't have a will. All her properties up to a certain amount will go to the spouse anyway. And after that, if there is further properties, then as the child, if you're the only child or if you're one of many, you will get an equal share of the remainder. But if she dies without a will, at the moment, the properties up to £270,000, certain conditions satisfied, will go to the spouse anyway. If she wants to make a new will, obviously there are formalities that she has to comply with, but you also have to ensure that the person who's making the will has the capacity, which means she is of sound mind. She will have to appreciate what she's doing. She'll have to appreciate the amount of wealth she is disposing of by way of the will. So essentially you have to make sure that she has the mental capacity to make the will. If she doesn't, or if there is any suspicion that she may not have that capacity, the will can subsequently be questioned and even challenged in court. But briefly, in your situation, if she is of sound mind, she is free to make another will. In any case, her earlier will is not valid anymore.
Thank you very much. We have few more questions, but I'll come back to you because we have so many questions, and we have questions on immigration as well. Nazir Naisab, again, welcome to the session.
Thank you.
And a brief question is that the home office appointment centers, are they fully open now or not?
Yes, they have opened and they have started working. In fact, one of our client is attending them today and submitting his biometrics and giving his sporting documents. So they are back on track and they are open.
That's great.
Yeah.
My information is that yes, they started working from 1st of June, and people started attending those centers 1st of June onwards, and now since the Prime Minister has made further announcement, further relaxation from 4th of July, so we see that more centers will be open and more appointments will be coming forth. There's another question on Facebook. Welcome, first of all. The question is that if student has come here in 2019 and the course is going to finish in Feb 2021, the students are going to be eligible for this new PSW visa which government has announced. But so I make this clear that the government made an announcement for those people who will be completing their degrees or master degrees summer 21 onwards. So summer means June, not before June. So Feb, it doesn't come under that. But yes, if you have completed your degree, master degrees in Feb 2021, you still can apply for work permit visas if you do find a sponsor here. You still can apply for startup visa if eligible, and you can also still apply for entrepreneur visas. But the PSW, whether they will call it PSW or not, but yes, this new 2 years work visa will be applicable to those who will be completing their degrees summer 21 onwards. The word summer means June onwards, because the session, all the academic session in UK, they finish normally in June. So that was the answer to your question. There's another question via email, and that is, if a charity organization, they are running a charity organization and they would like to register with the Home Office for Tier 2, so they want to become Tier 2 sponsor because they want to probably sponsor migrants, from people from overseas to do a particular kind of work. So these charitable organizations, I remember last week you did give a detailed discussion on Tier 2 anyway.
Yes.
But the charities, is the procedure going to be a little different?
Basically, any lawful business which has a genuine activity in the UK is entitled, and they can make an application to the Home Office for Tier 2 registration. And obviously charities, they are UK based and they are doing a lot of work. In fact, we are getting a lot of inquiries from our community because our people, they are doing a lot of work in charitable sector, especially the mosques and ministers of religion like imams. They have to employ those people. For that they need to be registered and they need to get a license from the Home Office for this purpose. So yes, charities, being reputable organizations in the UK. They are eligible to apply, and in fact if they are registered with the charities commissioner, that gives them an extra edge because they are already registered with the relevant authority, and they would have a certificate saying that, and that will help their application getting a positive result.
Okay.
Yeah.
So thank you very much. There's another Facebook question. Welcome, Nimesh. The question is, Narisa, we have FLR visa on basis of British child. I think they're talking about the 7 years policy. They got the visa under the 10-year category.
Yeah.
So can we, on the next extension, can we switch it to 5 years route?
Technically, it is possible. If it is only the child is the basis, then it is possible, provided they meet the requirements of the 5 years visa rule, which is normally that they must be earning at least £18,600, and they wouldn't have any. They should not have applied for any benefits, and they would not have any criminal conviction. If these general requirements are met and they are earning at least 18,600 in the UK, and that can be verified by way of at least 6 months wage slips and their bank statements, then certainly they can transfer from 10 years to 5 years.
Mm-hmm.
Yes, that is possible.
So my question is, I'll just add this bit. I think you, it wasn't 7-year based, it was on the basis of British child who got British nationality under 5 years category, and Indian, born to Indian parents, stateless,
Yeah.
and because the child became 5 years old, so they claimed the British nationality. So the child became British, and on the basis of child FLRFP application, they got 2.5 years visa under 10-year route. I think this is the correct question if I take it right now. So as Najisab said, that there technically may be a possibility, but there may be a hitch in my experience, because the 5-year parent route application, the requirement is that you came to the UK under that category, or you came to the UK under spouse category, right? So if you did not come under that category, which is the case, so then in those circumstances, Naisab gave a general information which is right. But in particular, if you're asking in your particular circumstances, if your entry to the UK was not in one of those categories, for example, you came as a student, your wife came as a student dependent, and later on you became an overstay, and on the basis of your British child who got British nationality because of 5-year stay in the UK, because he was stateless, and he got British nationality. So on those grounds, my opinion and my suggestion is that you may not be able to switch it to this category, a 5-year category.
Yeah.
But as a general, as Najisab said, that the requirements for that he has already mentioned to you. So I hope that would make any sense. Welcome to Adil Shahzad Saab from probably Ahmedabad, I believe. And that is for Imran Saab, I believe.
Yes, sir.
Isn't it?
Yeah.
Okay. Yes, Adil Aslam Saab, I hope you got the response from us. I'm just going through the list if there are more questions here so we can answer. There's a question from Abu Yusuf. Welcome. The question is in relation to 10 years route. If you apply for extension 3 months before your current visa expire, and you will get 2 years extension, will your next extension period will start after September, or will they cancel existing, and let's say decision made in August, so I'll lose 1 month for time? Yeah, first of all, you should not be making an application very early. You should be making application for extension in the last 1 month, and there are clear guidelines from Home Office that you should be making an application in the last 30 days, unless when you are going for indefinite leave to remain, for an example, then, and you have, if it is 5 years route or 10 years route, and you have still visa valid for 1 year, that is normally the cases when you are applying in the last month and Home Office taking still further 3, 4, up to 6 months. So they give you another 2.5 years visa. So at the end of the day, they accumulate, and at the end of the day, you may have extra leave. But here it is the opposite, and that is because of that. So if you are short of 1 month at the end, you still can apply 1 month earlier anyway. But if you are short of more than that, technically you should be making an application for FLRFP rather than under 10 years category. And once your time is up, you make the settlement application, or vary that application to settlement application, so your earlier fees, it doesn't go waste. So there is a technical issue, and I would suggest contact us or your solicitors if you have, or email us info@m-rsolicitors.co.uk. Again, 10 years question, Najib, there is another question, interesting question, and so many people are doing this unknowingly, the facts you are going to mention now, and they are getting refusals. And even they go to some lawyers, and probably they do not know much about it. So this is the combination of European regulations and UK immigration law. For an example, a person who is completing 10 years, he believes legally in UK, and on the basis of that, he is going to make ILR application on the basis of 10 years. However, in that 10 years, he has spent some time, or up to 5 years maximum, both scenarios we take.
Yeah.
Once he has spent less than 5 years, and in another category he has spent 5 years in EEA category as a European dependent residence permit he had.
Yeah.
So 5 years or 3 years of that, and then 5 years or 7 years of UK rules, 10 years completed. What are the chances?
Basically, once you complete your 10 years in this country lawfully, the rules require that you should have been here in this country lawfully and continuously. The rules does not describe it whether you should have a visa under the immigration rules, or whether you had the visa under the immigration law or the European laws, for that matter. So in together, if you have completed your 10 years, whether five of those years were under EEA law, or 3 years were under EEA law, and other 7 years were under immigration rules, you are eligible to apply, and you can clearly make that application, provide them with the relevant evidence, and your application can be successful. Although the Home Office guidance is misleading in this sense, and I think that's where a lot of solicitors are puzzled as well, because the guidance clearly states that if you are under European law in this country, we won't count your period towards 10 years. But as a lawyer, we are very clear on that, because as a lawyers we have to see what the law says, what law requires, and the law says that you have to be in this country for 10 years, and that should be, there are two further conditions, that your stay should be lawful. So if you had, for example, European visa, a residence card, or permanent residence card, or any other leave, so that leave is lawful according to the rules. So whether you had 3 years leave or 5 years visa, if in total your total is 10 years in this country, and that is lawful and continuous, then you are able to apply for indefinite leave to remain under normal rules. But if you are here for 5 years, then you have a choice. You can apply under European rules. That will save you a lot of money. You don't have to pay Home Office fees. It's just £65 you have to pay, rather than paying almost £2,400, 2,389 to be exact. So it will save you a lot of money, but you need to prepare your application properly and explain the Home Office as well that you have completed your 10 years, and on that basis you are applying.
Thank you. I just add a little bit into what Naji Saab said. First of all, if you look at the application form now, there's a specific question that out of 10 years, how many years, or even have you spent any time under EEA regulations? Okay.
Yes.
Now, I separate two scenarios. One scenario, as we have been discussing, that you have spent some time under EEA regulations but legally. That means that you made an application, and as a result of application you got that EEA residence permit. Then it says it is Home Office discretion to count that. So they will do that and it will be counted in 10 years route. The regulation, the time you have spent in EEA regulation will be counted there. Because they want to see that yes, your sponsor was still exercising treaty rights and you fulfilled the EEA regulation. So it is their discretion, and which normally they exercise in your favor. The other scenario is that you have been fighting your case under EEA regulations. You have not been granted visa yet under EEA regulations and 10 years are over, and you think, since I made this application, EEA regulation application, at the time when I was legal, say 2 years ago, when it was 18 years, and then I continued fighting it, and since still I haven't got the EEA resident permit, but my 10 years are over. So in this case, they may refuse, very likely they refuse your 10 years category leave, because the EEA regulation, you have not acquired the visa until today. So that is the tricky situation. So you need to consult your solicitors, or again, as I said, send us an email or see us m-rsolicitors.uk. We are getting more questions. There's just a quick answer I give you, Aisha. Thank you for joining us. You are asking what is the time scale for FLR FP applications. There is no specific time scale, but what Home Office is suggesting, after they issue the acknowledgement of the biometric letter, or once you have done your biometrics, the guideline says that they may take up to 6 months. There are many cases these days which are not taking 6 months. Take the COVID-19 situation out, but there are many cases still where they are taking more than 6 months. It really depends what kind of FLR FP application it is. Is it under the rules? It is under human rights? What it is? It depending on that situation. If it is under 7 years child category, then there's a different way of pursuing it. Different way, I mean that you should start chasing them after 6 months. But if it is something, a weaker case, normally lawyers tell you that, look, if you chase them, you may get refusal, so it's better to wait for a little while. So it depends really on your particular scenario. We are still getting more questions on immigration. I would encourage all those, if you have any other questions as well, which is not related to immigration, but you want to ask us. But I do have some queries in front of me, and I move on towards Sonia. Thank you for sitting patiently.
That's okay.
Okay. I have a question here, and the client is asking, I'm trying to rent a flat, but my landlord has asked me if I have a right to rent. What does that mean actually?
Okay, thank you. So when it comes to landlord trying to let their property out, they have certain obligations that they have to fulfill. And one of their obligations when it comes to letting the property is that they must authorize the property to an adult who is going to occupy the property, and that adult needs to have the right to rent, meaning that they have they're legal to stay, for example, and they haven't been disqualified as a result of their immigration status. So one other thing to consider with that is if the landlord fails to check with your immigration status, that's okay. If you already have a tenancy agreement in place, that agreement is still valid, so you can occupy the property.
Okay. So if I'm a landlord and letting a property to a tenant who is now gone into administration, okay, so can I use the rent deposit monies for the areas? First of all, if you can elaborate, what is this? There are schemes. You see, if I'm renting out something and I have paid deposit to the landlord, where now this deposit goes? Does it stay with the landlord, or there is a scheme where it goes, and then how do I come back to it?
So what a rent deposit is, that's the money that the tenant will give to the landlord, and the landlord will use that hold it on trust with the tenant, and they will use that, for example, if the tenant has arrears on their rent, or if they owe any other fees to the landlord under their lease agreement. So with rent deposits, they can be held in different ways. So for example, either the landlord or the tenant can actually hold the deposit. So different ways that the landlord can hold is they can hold the money in a separate account, which means that actually the tenant owns that money, but the landlord has a charge over that set amount. And it could also be vice versa, so the tenant can also have the same amount in another account and hold it on trust for the landlord. The other thing is the landlord can hold the money. They actually own it and hold it in a separate account. And then the one other option to bear in mind, which if either party is worried the other party may go insolvent, is if they hold it in a separate account as a stakeholder, which is controlled by a third party. So neither the landlord or the tenant. And that might be a safer option. But either way, when you do rent a property, make sure you have a rent deposit deed, and in that deed, it'll detail how the money is held and how much you need to pay and what the landlord can use that money for. And then the other thing to, like I say, to consider is check how much you have to pay, what they can use it for, and for example, if the landlord was to sell the property, make sure that the deposit you've given to the landlord, if you've given it to them direct, gets transferred to the new landlord as well. So just make sure if you get served notice that the landlord sold the apartment or the house, just make sure you ask where the deposit is being held. And then if, as you were saying before, the tenant was to go into liquidation, one option for the landlord is if they haven't drawn on the deposit deed, then the sums in forming part of the rent arrears can be used by the landlord, so they can take that money. And if there is any other unpaid terms under the lease, and the landlord would be able to access that money before any other creditors. So hope that helps.
Yeah, that's great. Thank you. A similar question: If I'm a private landlord and I would like to serve some documents or certificates on my tenant, and he's not opening the door.
Okay.
So if I just put through the post, will that be acceptable? How do I prove that, or how do I compel him to receive the documents?
Okay. So the regulations do permit for landlords to give the information such as an EPC or the gas certificate, and you can either give this to them via hard copy, so actually physically giving them the paperwork, or if you can send it via email. So for example, if when you agreed to lease the property, if for serving notices the tenant had agreed to accept notices via email and they have a valid email address which they've given to the landlord beforehand, you can use that email to serve documents. And then with the current COVID situation, the court may consider it in your favor if you actually do post it through the letterbox. So that's another option you have. So either post it or you can email if you're allowed under the lease.
So if they're posting, they take a photo that they're posting to make sure that, yes.
It would help. So if you have proof, you just basically, as a landlord, you need to have proof that you actually did serve the notice, for example, or certificates, and you can show them putting through the post box. Or if you have like recorded delivery, for example, if you did post.
Okay, that's great.
Or they can get a certificate of posting from the post office that comes free. Whenever you're posting, you can ask for a certificate of posting, and that will be helpful as well.
Yeah.
I hope you understood the information given by Sonia and Najisa, but if you still have any further queries, you can email us on info@m-rsolicitors.co.uk. Our office number is 0208 518 1956. Moving on to further questions, Salman, I have here, I thought just try to get as many as we can today. The question is, I have been running a small and successful business for more than 10 years in Luton. Since the start, I employed someone who is very efficient and loyal. Recently, I have been having some cash flow problems and urgently need capital. The employee has expressed intention to invest in the business, but said he will only do that if I give him a share of profit. How can I take the investment without giving away ownership of the business? Very interesting question. Thank you very much for sending this kind of questions. Salman, yes.
So there are quite a few ways that you can raise capital for a small business. One of them, obviously, going to the bank, but in the present climate, not many people are able to obtain a loan from the bank. So if your employee or if anyone on a private level is offering to invest, it may be something that is very useful to your business. However, you have to make sure that the terms of you accepting such an investment is very clear between you two. If that person has expressed an intention to invest in your business, but only on the condition that you give a share of your profit, it seems like that person is not giving the investment just by way of a loan. Because if it was a loan, then you'd be paying an interest. If it's a share of profit, it's not just as a loan. So there are a few ways you can formalize it, one of which is to draw up an agreement for investment, where that person's investment is recorded and the terms of your return is also recorded. It can be a share of profit that can be determined year on year, either by yourself at your discretion or at a mutual rate agreed, given that the company or your business makes a certain level of profit. It's important to get those details in, because on many occasions where these details were left out, later on a problem or a dispute or a disagreement arose whether you are giving a fair share of profit. A share of profit is very indefinite, you see. Your profit may not be the same every year, and even if it's a percentage, it may not be to the other person's satisfaction or expectation every year. So it's very important to get the details down by way of an agreement. The other option, obviously, which is open to you, but you probably are not interested in that, is that you can take that person on as a partner. Now, there are many different types of partnerships. There are partnerships where you don't a partner may not be allowed to make any management decisions or any direct involvement in the business, but still a partner just because there is an investment. So there are many types and various different types of partnership agreements and arrangements that you can look into. If you speak to your solicitor, he'll be able to give you a fair number of options that are available to you, even under a partnership agreement, but may not, it may actually be something that suits your requirement, even if at the moment you feel a partnership is not what you want. However, if it's, if you really want to steer clear of any partnership whatsoever, I would suggest that you drop an agreement that records the investment, and you put the details down as to what the rate of return would be to that person, at what frequency, and what happens if there is no profit, and what happens if the business stops operating, sometime down the line. It doesn't necessarily mean you expect it to happen, but it's always good to have those options clear and in very clear terms in your agreement. But I would say explore all your options and have a detailed discussion with your solicitor.
Interesting.
Thank you very much. That was really interesting. Another interesting question I have for you, Salman, and that is, the question is from client that my father owns 2 properties in UK. He lives in one with the mother, and the second one is rented out. We are 5 siblings. I don't know, he didn't mention where they live, but okay, we are 4 brothers and sisters. My father suffers from cancer, and we want to ensure that our mother can continue to live in the same house after my father's death, if that comes to. Will she need to pay any inheritance tax on the property after my father's death? And also, what happens to the second property? Very interesting. Inheritance tax.
You didn't. It's not clear from the question the nature of ownership of the house that your parents live in at the moment.
It seems that father only owns the property.
If the father owns the property on his own, then if there is no will, I'm assuming there is no will, but if there is no will, the laws of intestacy will apply. And upon your father's death, your mother, who lives in the same property, will get the house up to, there is no inheritance tax to pay, first of all, if the spouse, which is your mother, gets a property up to a certain value, which is £325,000. So up to £325,000, your mother does not need to pay any inheritance tax, and she will get the property in any case. She'll outright get the property that she's living in at the moment. With regard to the other property, that depends on the value of the property, really. If it's over a certain amount after the first property, then your mother will get half of the ownership of that property and any other property, and the remaining half will go to you and your siblings in equal proportion. However, your question obviously is concerned with whether your mother can continue living in that property. It's difficult to say how she will, because you didn't specify the nature of ownership. But it seems, if you assume that your father was the only owner and your mother and father are the only residents in that property, she will get the house that she's living in as a matter of course under the laws of intestacy. The other property, it depends on the value, but prima facie it is likely that she will receive half of the ownership and the other half will go to you and your siblings.
Thank you very much. Very useful information. More immigration questions we are having. Imran, you asked a question that if spouse visa was refused on the basis of TOEIC, that you had issue with the TOEIC, but then on the appeal it was allowed. Now you want to go for indefinite leave to remain on the basis of 10 years legal residency in Feb 2021, and you want to know the implications of TOEIC. Now, if the TOEIC issue was resolved in your favor at that appeal, then it is very, very unlikely that Home Office will bring it up again. However, if the TOEIC issue was not resolved in your favor at appeal, but because the appeal was also on the basis of spouse visa, and under the spouse visa category, they did still allow you, say, under 10-year route, 2.5 years visa, 30 months visa, then Home Office still can come back and refuse your application on the basis of TOEIC. So you need to consult solicitor properly, showing him the court determination, what they say about it, what were the Home Office arguments on that, and cover that and justify that in your application when the time comes in February 2021. I hope I understood your questions properly and I answered it properly. There was another question from Mr. Khan, Sharif Khan, welcome. As I understood, that you are trying to say that your old passport, which is expired, obviously it is with the Home Office, but your new passport is with you, your matter is in the court, and you want your old passport, can you get it or not? Normally the documents, the identity documents, mainly passport, Home Office does not return until the case is settled in your favor. Because if it's not settled in your favor, normally they keep the passport and they want to enforce your departure from UK, and they use that passport. Since it is expired and you already got a new one, but new one is with you, so they can ask you, why do you need that? You need to give them reason to get that passport back. So my understanding is it will be difficult, but if there are some exceptional compassionate circumstances why you need that passport, sometimes it is valid, and you are gone for registration, and registration people, they are asking for that passport, or they want a tested copy, then you pursue the Home Office on those grounds. But in this particular case, it is expired. You may be thinking that it's expired, it's not worth for Home Office to keep it, but Home Office may ask you, okay, send us the new one, which is a valid one. So I don't advise you to contact them in this circumstances, since you don't need that. But if the appeal is allowed in your favor, you have been granted visa, I'm sure they will return your passport. If not, you can chase them definitely, and they will return your passport. There's another question from Qazi Jawad Sahab, and there's a request obviously that Qazi Jawad Sahab wants an answer from Qazi Imran Sahab. So that will take us to Qazi Imran Sahab, and I have a few more questions related to asylum as well, which I'll ask you. But let's start with Qazi Jawad Sahab's question, who's asking, very interesting question this is, and I would like to know the answer from Qazi Sahab, and if need be I'll try to add something if I think need be. And the question is, if a person feels insecure in his own country of origin, and he wants to, on the basis of religion, race, ethnicity, political, something like that, which comes under, say, asylum category, can he go to British High Commission in that country and claim asylum? We have seen these situations in movies, okay? So I've given the answer, but I will ask Imran Sahab to elaborate on that.
Thank you very much, sir. Thanks, Qazi Jawad, for asking such a lovely question, and it's my field of interest. Yes, someone can, if asylum claim is of a high significance. For an example, is 2-3 asylum cases, 4 asylum cases I will quote. Yes, you can, under the United Nations Charter of Human Rights. If someone has a life threat, for an example, you are in Pakistan and you are a political activist yourself, and you have a life threat and you go to the UK High Commission in Pakistan, yes, you can claim asylum, or America or anywhere like any European country. I start from few years back, 1998, 1999. It was a famous landmark case of Saima and Arshad, which was a love marriage case. It happened in Karachi, Pakistan. That case was projected in whole of Pakistani society, and so many demonstration spread. And at least then Australian government, they applied, they went to Australian High Commission, they walked in and they got refuge in Australian High Commission, and then they were taken from us from Karachi, Pakistan to Australia. Similarly, another very famous, world famous case, which I think everyone knows about this, it's a Julian Assange, the WikiLeaks founder, who has who made a claim against his life threat against United States, a powerful country like United States, and he made claim in UK, Ecuador High Commission in UK. So that is another example. Malala Yousafzai is a prime example in the recent era, Malala and Julian Assange. So Malala case was the similar in nature. They granted her refuge, her status, and then they flew her to UK. Similarly, another case which is recently, it's famous in all around the Pakistan, Askia Bibi case is the prime example of this case. So I hope I clarified your question.
Thank you very much, Mian sir. Ji Qazi Jawad sir, I think you got the answer, that if it is of very high significance and importance, yes, you can go to any High Commission in your country of origin who are signatory to UN Convention 1951, Refugee Convention 1951. You can't go to any country's High Commission where they are not signatory, but if they are signatory, yes, you can, and then they will give you because as soon as you enter the High Commission,
yes,
you are not in your country.
Yes.
You are in the country of that High Commission. This is the diplomatic rules, as we know. So thank you very much, Mian sir. There are more questions for you, and there was a question and there was a repeat question from in USA that if someone has got refugee status in USA, can they return back to their home country after getting the status? I think we did answer this, but okay, this was repeated again.
Sir, if actually it's a clear, if it's the refugee status granted and someone leaves United States and go back to native country, obviously that will void its asylum claim, so then he or she can't go back. If they go back, their asylum claim can be treated as a withdrawn or can be treated null and void. So because during this status he can't go back, the reason being that if someone claims asylum and they claim that they have a life threat, and if they go back during the process, so it means their life threat is ended. However, if they've been given indefinite leave to remain or citizenship of specific country, for example, this question was asked from United States, then yes, they can go back once they come out of refugee status and got the permanent citizenship or the indefinite leave, permanent citizenship or the indefinite leave to remain. In this scenario, sir, another thing is some people they claim asylum and they don't get indefinite leave or they don't get refugee status. However, due to consideration of their claim or considering other compelling circumstances or factors, some government they issues human right visa. On that specific visa, if it's not the asylum decision and they refuse the asylum claim and they issue human right visa, then that claimant can go back to their native country during the visa.
Thank you. Salman, there is a challenge to your information and the response I have from Mohsin. Thank you, Mohsin, for joining us. Mohsin is saying that Salman mentioned that the transfer of the house between spouses is subject to 325k threshold. Okay. So he wants a bit more clarification that there is no inheritance tax to pay. He's saying there is no inheritance tax to pay on transfers between spouses.
Yes.
First of all, is that correct? If this is correct, then probably it is getting mixed up with the other earlier one. In fact, the spouse transfers their nil rate ban to the spouse to be applied when the assets are to be transferred to surviving family after the second spouse passes away. So we need a little more clarification. Probably there are mixed answer.
No, I think there was a misunderstanding, and I probably wasn't clear enough. The inheritance tax nil rate applies to any transfers between spouses. That is not limited to 325.
Yes.
And obviously, property is transferred to the wife on a nil rate band anyway. 325,000 pounds threshold comes into play when it's transferred to other members of the family,
Right.
or any other one,
Right.
any other person under will or even intestacy.
Right.
But the transfers between spouses is obviously nil rate, no matter what the value.
So once again, thank you very much for bringing this up, because if you understood this way, then probably many other people may have understood this way. So Salman has clarified that. Sumbal, you have asked question. Welcome to the session. And the question is 5 years. Okay, so you are going for ILR under EA regulation, and you are saying that do we have to submit 5 years evidence, like say 60 months of bank statements? No, it's not like that. So for example, every year there are 12 months, you can just send 2 to 3 bank statements of that particular year, and similarly for each year, and then you have utility bills. So my advice is to my clients, for example, if you are sending January 2019 bank statement, and then you are sending August 19, and then you're sending December 19, 3 statements. So then say you have electricity bill as well, don't submit electricity bill of these months. Say submit it for Feb, March or April, and then you have another utility bill, then submit that utility bill for another month which is not covered by the other evidence. So if you can grab 3 to 4 variety of evidences for each year, then it will be only 5 to 6 documents maximum for each year, which is acceptable. So yes, no need to send 60 bank statements. Probably all together there may not be 60 pieces of documents you need to submit. I hope I've answered your question. Moving on, there are more interesting questions we have. Okay, this is very, very hard question, Imran, sir, for you.
Yes,
coming up.
sure.
That in this COVID-19 situation, even Home Office statistics says,
Yes.
it gives us very amazing data that so much of domestic violence cases have only been increased in UK because husband and wife living together more than normal circumstances. So, but in terms of immigration, what happens to a person who is on spouse visa?
Yes.
He got 2.5 years visa and still 2.5 years to go, or he has got an extension and still some time to go before he go for indefinite leave to remain, and he becomes victim of domestic violence.
Yeah.
What route, and there's no children as well, so what route is available for him in terms of immigration?
Thank you, sir. Actually, set DV is always there, domestic violence. Is whoever is the subject of the domestic violence, he or she can straightforward apply for domestic violence category, and that is straightforward indefinite leave to remain, and there is no Home Office fees involved. But however, they need to prove that they've been subject to domestic violence or domestic abuse.
Thank you very much. I'll add a little bit on that. Yes, you can do that. Set DV, there is it's a temporary application even before that, and that temporary application, for example, you are not a spouse of a settled or British person in the UK anymore because of separation, so it is your duty to inform the Home Office of any change of circumstances. So, and you also need some time to gather the evidence, the documents, to make this set DV application. So what do? So you straight away make an application to Home Office, and they will, within 2 to 3 weeks, they will grant you 90 days visa. 3 months visa, your previous visa is gone, you have been granted 90 days visa. So in this 90 days visa, either you can work full time to support yourself, or you can even go and claim all sorts of benefits which a British national can claim in this country because you are in that destitute situation. And then if you are in that situation, the set DV application will be free for you. And all the NGOs and the organizations who are supporting victims of domestic violence will be available for you. If you need accommodation, you need legal assistance, legal aid, they will be able to help you. But if you are earning and you want to do it yourself, yes, you can afford, you can still do it. The evidence mainly they require is, for an example, a report from your GP. So if you are a victim of domestic violence, first of all, what you need to do is tell your doctor If you have gone into depression, you need to tell your doctor. So your treatment can be started, and at the end of the day, you will need that medical report to support your claim. Then if it is of very serious nature, then police has to be involved. So if there is a warning, a case reference, or a case actually the other partner has been charged with any criminal offense, that you will need to prove your case, or at least a order, an injunction, protection order, non-molestation order from family court, and it is not an ex parte or interim order. It has to be full order, which is normally given after giving notice to the other party. So again, this is the area where you do need a proper legal representations. Our details, as I say, info@m-rsolicitors.co.uk. Not many people know about this, and they try to do it on children basis. If there are children, yes, you can do so as well. But on children basis, you will be given further 2.5 years visa. So you still have to qualify or continue 5 years and then go for indefinite leave to remain. But in this category, it doesn't matter if you have been in the country for a few months and still 4.5 years to go. But under this category, you will apply for indefinite leave to remain straight away. And now this is the situation for European spouses as well, which was not there before, long time ago. But now the European spouses can do the same. Thank you very much, Imran sir. So coming back to, still we have few minutes, so I'll try to cover more questions. Okay, this is very, very interesting question. Najis,
Yeah.
Probably we need your expertise as well.
Thank you.
Zishan, thank you Zishan, this is very important question. It's very unusual question. We do love to have unusual questions, which gives us more information and which gives us something to think about out of the box. So the question is, can we get a surrogate mother from another country to act as a surrogate mother? Please advise. So if we can, will that be still a visit visa, spouse visa, fiance visa? What kind of visa? I'm sure, yes, you can make any application for anybody from all over the world, but your interesting question is, so we have few views here, and then we try to give you information. So Najis,
Yes, unusual question, unusual scenario. Certainly, if you are in this situation, then clearly you can make an application to the local embassy, provided with the relevant evidence, and they can certainly make an application. Obviously, that has to be, they have to give us specific reason why they want this special person from this special country, and why they cannot get someone from the UK.
this is what I was writing down here to ask you, but yes, cleverly
Yes.
you said that. Yes.
Yeah,
Good.
because when you make such an application, Home Office is always suspicious of such applications. They first want to make sure that your application is meritorious and that it is genuine. So they will try to cover all those corners. So if you are satisfied that this is the right person for you, for example, if you, for example, like that person for whatever reasons, you think that that person can be a good mother for your child, or that person has specific traits. For example, nowadays people are having, they are choosing the DNA even of their kids. So
scientifically evidence
Yeah.
will be helpful.
yeah, so if you have this preference or a choice that you want this particular person, for example, that person is, for example, a professional or highly educated person, so you want that person particularly for that particular reason, so that those characteristics are then transferred to your child, so then you might have a legitimate reason to ask for that particular person, that this person should be granted visa. So all these things, all these avenues, you need to think about those and then apply. But technically it is possible. Yes.
But I'll shed some further light
Yeah.
further to my learning colleague. Basically, surrogation they don't take is something very compelling and disease. They says it's a normal procedure. So recently this came across in Ukraine where so many surrogated mothers and babies they stuck due to the COVID-19. So in very unusual scenario, like Mr. Naji shed light that you can make application, but it's very unlikely. So normally circumstances they gave birth in the second country, and then obviously the baby will be your baby and you can bring him back. So that's, I think, legal protection for the baby, but not for the surrogate mothers.
Yeah, so this is why I was saying, which Imran Sahab has highlighted already, thinking out of box scenarios, since we claim that we are solution providers. So what Naji Sahab said and what Imran said, I'm just trying to mix up and giving another opinion that yes, first of all, they have to be sure why you have chosen this, and Naji Sahab has very beautifully explained that. And what options you have already availed in UK. Okay, this is very important. Then your financial strength and everywhere. But if the objective, obviously the objective you will mention there is child. Okay, so Imran Sahab very clearly told you that it's going to be a difficult case because your objective you want to achieve is the child. And okay, if you want to take this particular route, which is fine, and you have valid reason to choose that particular lady to do all this, that's fine as well. But why it cannot be possible in that particular country? And once child is born, on the birth certificate of the child, the name of the father will be Mr. So-and-so, who is probably already a British national in the UK. And due to that reason, because he's British national already, the child born anywhere in the world to him is also British national. So child can come. So you have to clear your objective. So if the objective is child, then yes, it is possible child can come this way. But if you want to bring surrogate mother, it has to be very compelling and compassionate case. Under the rules, they are going to very likely dismiss your case, and you may have to go on appeal. But if it's a visitor visa application, obviously it would be, there will be no appeal. You may have to go for judicial review. So you have to make it very compelling, compassionate, and you have to have so many references from, say, even your MPs, your doctors, and create a history, a background behind it, why you need from that particular country and from that particular mother. There has to be some link between your family, their family, and so on, so forth. So I believe this is very interesting question and very interesting answers by both of you. Thank you very much. We are coming towards the end, but I have just a couple of questions more, and if we could not answer your question, then we will do so later on, and you can still send us email on info@m-rsolicitors.co.uk for appointments. You can call 0208 518 1956. So one, two more questions I just run through with nice of you, I believe. This is a very straightforward question. I'm married to a British national, and I've been granted ILR already. So when can I apply for nationality? Do I have to wait for 1 year after my ILR, and plus obviously 5 years and 10 years?
Yeah, this is actually a tricky situation which a lot of people and some solicitors, they get it wrong, because normal rules require that once you are granted indefinite leave to remain, you should then wait for a year to apply for naturalization. But there is an exception which this client comes in, that because that person is married to a British person, so he's basically entitled to make the application for naturalization as soon as that person gets ILR. So now it's that person's choice whether he wants to apply today, tomorrow, or within a year, or whenever he wants. But he's entitled to make that application anytime once he gets his ILR, provided his marriage is still valid with that person.
Of course. So general requirements remain the same: the 5 years residency, the 10-year good conduct behavior category requirement is there, the English requirement is there. The only question you asked was I going to wait for 1 year? Not. No, if your spouse is a British national. But if the spouse is on indefinite leave to remain or any other category, refugee status or whatever, but not British national, even European but not British national, you still have to wait for at least 1 year after your indefinite leave to remain, including the other requirements. So I think that would be all, and I would like to stop here. There are more questions. We will try to do those inquiries which came by email. We'll try to respond by email. If your Facebook questions are still there, we will try to answer on Facebook. I would like to thank you, Salman, Imran, Sonia, and Najisa,
Thank you.
and we will try
Okay.
to reach you next week sometime as well, with probably most likely a different format. So if you have any questions, please do send us email and we'll try to answer them as soon as possible. Until then, stay safe, stay connected with us. Thank you. Bye-bye.
Bye bye.